a pretrial conference. And Mr. McQuarrie, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McQuarrie, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court?
This case is a perfect example of what happens when internet law collides head-on with real courtroom authority. What you're about to watch isn't just a pre-trial conference. It's a psychological chess match between a self-proclaimed sovereign citizen and one of the strictest judges we've ever covered on this channel. Judge Bryant doesn't posture. She doesn't argue philosophy, and she absolutely does not entertain courtroom theatrics. On the other side, you have a defendant who believes names written in capital letters, procedural loopholes, and personal feelings can override decades of established court rules.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know, as it relates to this pretrial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court.
You're going to be restrained every time you go off course. So, understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McQuarrie, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias.
Right here is where the familiar sovereign citizen playbook makes its first appearance. The insistence on lowercase letters and rejecting corporate capitalization is a long-standing pseudo-legal theory that courts have repeatedly dismissed across the country. It's rooted in the false belief that altering the formatting of a name somehow separates a person from legal responsibility. Judges hear this argument constantly, which is why you'll notice Judge Bryant doesn't react with surprise. She reacts with control. To the court, the defendant standing before her is a defendant named in the case, regardless of fonts, capitalization, or philosophical objections.
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McQuarrie and ask him how does he wish to proceed with the hearing for Mr. McQuarrie.
Yes, Your Honor. Violation in code of judicial conduct, Judge. And I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McQuarrie, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McQuarrie. Thank you, Mr. McQuarrie.
Yes, ma'am.
Your Honor?
Yes, sir.
They indicated that he would need to file a motion for recusal before you, and if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion.
This is a pivotal moment, and Judge Bryant draws a hard line immediately. Courts are not forums for emotional validation. They are procedural environments governed by rules, timelines, and legal standards. When the defendant frames his argument around feeling disrespected or restrained, the judge shuts it down without hesitation. And that's not cruelty, that's clarity. Her role isn't to debate tone or perception. It's to move the case forward efficiently and lawfully. This exchange highlights a major misunderstanding many self-represented defendants have. Personal feelings do not override courtroom procedure.
Motion, I denied it. So tell them it's denied. I'm not I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
Pay close attention to how deliberate Judge Bryant is here. She isn't threatening, yelling, or escalating. She's explaining consequences in advance. Every time she says, you'll be restrained, she's referring to courtroom control, not punishment. This is how experienced judges manage proceedings. They establish boundaries early, so there's no confusion later. The defendant, however, interprets this as suppression rather than structure. That disconnect fuels attention. The irony is that the judge is actually giving him more guidance than most defendants receive, repeatedly explaining what this hearing is, and more importantly, what it is not.
All right. So, Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is no?
Sir, if you just, I promise you, I've been on the bench for 16 years. And I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Here comes a nuclear option. The motion to disqualify the judge for alleged bias. On paper, this is a legitimate legal mechanism under Michigan Court Rule 2.003. But context matters. Motions like this succeed only when there's actual evidence of prejudice, not disagreement with rulings or tone. The speed with which this request is made tells you everything. It's not strategic, it's reactive. Judges see this tactic often from defendants who feel they're losing control of the room. And notice Judge Bryant's response. Calm, procedural, and immediate. She doesn't argue defensively. She simply processes the request exactly as the rules require. That's professionalism, and it's also why these motions rarely go anywhere.
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McQuarrie, I don't take things personally. Ms. McQuarrie, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And correct. Maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed.
When Judge Bryant mentions her 16 years on the bench, it isn't ego, it's context. Experience matters in a courtroom, especially when dealing with unconventional arguments. She's signaling that she's already seen every variation of this strategy before. The defendant believes he's uncovering hidden truths, while the judge knows he's repeating patterns that never succeed. This moment also highlights something important. The judge isn't rushing him. She's asking him to listen. Ironically, the very information he wants is being offered, but only if he allows the process to function. This is a classic example of how self-representation often works against defendants rather than empowering.
I have denied the recusal. You have requested an appeal. I have granted that appeal. and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
This is where the conversation takes a sharp, emotional turn. When the defendant invokes race and age, he's attempting to reframe the interaction as personal injustice rather than legal procedure. Judge Bryant shuts that down immediately and correctly. Identity does not alter the application of the law in this courtroom. Behavior and legality do. Her response is firm but precise, redirecting the conversation back to what actually belongs on the record. Courts cannot operate on emotional narratives alone, and this exchange underscores a danger conflating personal experience with legal standing. It's a moment that feels dramatic, but legally, it changes nothing. This case ends exactly where it was always headed. Not with a dramatic ruling on guilt or innocence, but with a procedural conclusion shaped entirely by the defendant's choices. Judge Bryant followed the rules, honored the recusal request, denied it properly, and ensured the appeal process moved forward correctly. The takeaway here is simple but powerful. Courts reward preparation, clarity, and legal relevance, not defiance or internet theories. This hearing could have gone very differently with counsel involved, but instead it became a lesson in courtroom reality.